The jury is now deliberating in the James Crumbley trial. They had about an hour and change to deliberate today. They're going to be deliberating more tomorrow, and we'll see if we actually get a verdict tomorrow. One interesting thing that we do know from the end of today's trial is that the jury already put in a lunch order for tomorrow. It would seem to suggest that they have a few hours of material to discuss and facts and evidence to discuss, and it doesn't seem like they're going to just come in tomorrow morning and have a verdict within an hour. But you never know what happens in jury deliberations. Maybe they just ordered their lunch just to be sure that the lunch would come if in case they do end up deliberating longer. But as it stands now, they're coming back tomorrow to deliberate, and we'll see what happens then. We'll see if we get a verdict tomorrow. In the meantime, let's jump into some of the closing arguments that were made. And like I always do, I'm going to give you some of my opinions and maybe certain things that I would have done a little bit differently if I was the prosecutor, if I was the defense attorney. I thought overall both did a pretty decent job in closing the case for the state and closing the state for the defense attorney. I think they both did a pretty decent job. I'm just going to make some suggestions or some things that maybe I would have stressed or done a little bit differently. So before we jump into that, though, I'm getting some pressure from my producers that I have to push more my store. If you look in the description, you will find a link to the Brother Counsel store, and you'll be able to get some products as well as support the channel at the same time. So what can be even better? It's very hard to imagine anything better than that. But if you are not there just quite yet, then please at least subscribe and like the video so we can show some love to the YouTube algorithm and get this message and this analysis out to more people. As you know, you don't get this analysis anywhere else. So that's now that my producers are happy. Now I can talk a little bit more about the case. One witness, before we jump into the closing arguments, one witness which was noticeably absent from the James Crumbley trial, who was not absent at all for the Jennifer Crumbley trial, was the firefighter Brian LaRoche. And if you've been following the Jennifer Crumbley trial, you'll know that Brian LaRoche was good friends with Jennifer Crumbley, and they had some text message exchanges, and some of those messages were deleted, and some of those messages were incriminating and not so great for Jennifer Crumbley. And that's a lot of the reason why the prosecutor called Brian LaRoche. Now, what also came out during his testimony was that he was actually having an affair also with Jennifer Crumbley. Now, how that actually came in was a discussion for another time. The defense really filed a motion in limine, and at some point during her cross-examination it came in. There's much more of analysis about how that all unfolded in the live video that I did a few days ago with a national trial attorney, Solomon Radner. You can take a look at that if you haven't seen that yet. But the point is that Brian LaRoche was having an affair with Jennifer Crumbley. And the question really was if Brian LaRoche was going to be called in the James Crumbley trial. And this national trial attorney, the criminal defense attorney for over 14 years, he felt that actually would be helpful to James Crumbley if that fact of Brian LaRoche having an affair with his wife actually came in. It would invoke some sympathy from the jury for James Crumbley that his wife was cheating on him during this time. And it can also help, I guess, explain the dynamic in the relationship between Jennifer and James, and it can kind of paint James as more of a passive, the passive parent or passive partner, and Jennifer much more of the one who's in control. And whether you agree with that analysis or not, that's neither here or there. But the point is that that's what this national trial attorney felt. And now that the trial's ended, we see that Brian LaRoche was not called. So should the defense have called Brian LaRoche and had that information come out, and exactly how they would go about bringing him in and why that would be relevant to James Crumbley's case, that's a discussion for another time. But at the end of the day, we see that he did not end up testifying, so therefore we're just left with the witnesses that did testify. So let's jump into the closing arguments. And it was interesting to see how the prosecutor started off, how she opened her closing arguments. Some attorneys like to start their closing arguments very quietly and just thanking the jury and kind of build it up that way. And some attorneys like to go in and boom, right away say something strong to the jury and something that would just blow them off their seats or get them listening. So, you know, different styles, and one's not more right than the other. It's just different opinions about how to go about doing a closing argument. Now, in this case, the prosecutor started off right away with trying to paint a picture of how surprising and how shocking this whole school shooting was. And therefore, she right away said that the detective, this is how she started off her closing argument, that the detective who was one of the first responders to the school shooting, he was so shocked about what happened and he couldn't believe it. And the only thing that he did remember is that he told somebody, some other detective or some other person, that no, this is actually real. It's actually happening. It's not just a drill. It's not an imaginary. This is not a fantasy. This is actually happening. So that was one thing. Also, he said that this was the most serious response that he's ever seen, and the second one that he's experienced doesn't even come close. And he's been in law enforcement for many, many, many years. So also just to show the shock of what type of shooting and how much in shock everybody was. He said that the kids looked like zombies when they were coming out of the school. He'll never forget the looks on the parents' face. And she also spoke about Molly Darnell. Molly Darnell was a teacher who was actually shot in the arm, and she couldn't believe it, what was going on. She was also in shock. And of course, Christy Gibson Marshall, who was the assistant principal who was tending to Tate Meir and trying to resuscitate him. And instead of going on lockdown, she actually went to the hallway and actually had an exchange with the shooter in this case. And everybody was just so in shock. And that's the picture that she's right away painting initially in her closing arguments. And then she moves on that really this case is not about the actual shooter. The shooter has been convicted and sentenced. And this is really not what this case is about. This case is really more about James Crumbley and his actions or his inactions. And then she goes through the elements and she explains what the jury has to find. They have to find there's two different theories, and you don't have to agree with both theories. If you find even one theory was satisfied, even if another juror finds that that theory wasn't satisfied, but the other theory was satisfied, still you should come back with a guilty verdict. And she explained that there's really two different ways to look at gross negligence. It's either gross negligence in the performance of a lawful act or grossly negligent in failing to perform a legal duty. And the legal duty in this case would be the duty that every parent has to ensure that their minor child does not inflict harm on other people. So those are the two different theories. She explained some of that. And then she also explained that there can be more than one cause of death. Just because the shooter was sentenced and he very clearly caused the death, it doesn't mean that you're limited, that that's the only person that can be charged. A proximate cause means that even if there can be multiple people that are responsible, multiple causes, and as long as it meets a proximate cause, doesn't have to be the only cause, then James Crumbley can still be found guilty. She spoke about reasonably foreseeable, that this is something that, and something that she stressed a lot, was that we don't have to prove to you that James Crumbley knew what his son was going to do. And that was a very important thing to stress to the jury, because as we saw from opening statements, and we're going to see again in closing arguments, that the defense attorney is going to argue that James Crumbley did not know what his son was going to do. And the prosecutor has to very clearly say that that's not our burden. We don't have to prove that James Crumbley knew what his son was going to do. It was just that it was reasonably foreseeable and what could happen if he does not take certain actions. So that's our burden, and that's what we're proving. So that was something that she stressed. And she did also go a little bit more into gross negligence, that it's more than carelessness, as we spoke about in a previous video in the opening statements, that this is something that's straight out of the jury instructions, that gross negligence is more than just carelessness. It's willfully disregarding the result that might follow from an act or failure to act. And then she explains some of the three elements that you have to find in order to find gross negligence. Then she continues, and she says the following. She says, "My job as a prosecutor is not to convict people. My job as a prosecutor is to tell you the truth. We are here to seek the truth. And yes, I have to advocate for the victims in this case, and I have to believe in what I'm doing, but that my job really here is not to convict people. It's just to show you the truth." And the reason why she explained that is because she wants to now explain to the jury why she had to show certain very graphic and horrific details of these murders of these four very innocent children. And therefore, she explained to the jury that the reason that I'm doing that is because I need to tell you the truth. That's my job, to show you the truth of what happened. And that's why we had to show you those very emotionally charged pictures and videos. And then again, she stressed something which I also made a point of in when the opening statements, is that one of the things that you have to do as a prosecutor is to show how easily this all could have been avoided. If the defendant would have just taken some very easy steps, some very easy opportunities he had, very many opportunities, but they were just very easy for him to do, and this all would have been avoided. And that's a strong point to make as a prosecutor, to show how easy it was for the defendant to act in a certain way and prevent all of this. And she said that he had so many opportunities and all he did was nothing, over and over and over again. He just ignored all the signs, and he ignored the safety of others, and he just completely ignored it. And she's trying to build up that would be willful disregard. It's willfully disregarding the safety if you're consistently not doing very easy things that could have prevented all of this. Then she continues to explain that the relationship between James and the shooter could not have been such a special relationship. She said that there's only 65 text messages between the father and the shooter, between James and the shooter, over a year's time. Only 65 text messages. He was aware that the shooter was looking at ammunition. Remember, that happened in the school, that he was caught looking at ammunition in school, and there was a voicemail left for Jennifer, which she told James about. So he did know about this, that he was looking up ammunition in school. And again, even though the tone of that voicemail was not so urgent, and that it's okay if he looks at ammunition, just he shouldn't be doing it in school, but still it's something that James knew about that he was doing, and put with the totality of everything going on, then he should have taken certain steps. Then after the school meeting, as we know, there was a school meeting with the counselor and the one of the principals. So after the school meeting, he didn't go home straight away to check on the gun. He only went home to check on the gun after he heard that there was an active shooter. So that's, again, ignoring his duty to protect people from his son's actions. Also, she said that even though he passed his house many times when he was a DoorDash driver, he passed the home many times. He could have just quickly jumped into the home and seen if the gun was there, if the ammunition was there, and he didn't do it. Then she made a point of saying that something that James said in the interview with the police was that it was doodling on a math sheet. And she tries to show that this was really not consistent with what the text messages show when Jennifer sent that math paper with all the drawing and all of those words on it. That when she sent that math paper to James responded with WTF, which shows that he wasn't just that it was just doodling. He was actually very concerned about it. And now he's trying to play it down with the police. And something that she mentioned is that's the things that he did not tell the police during that interview. He didn't say about the lock, whether the safe, he didn't say anything about the cable, or that he didn't tell them that the school wanted him to get help for his son at a meeting that they had with the school. And he didn't say that I don't know how he got the gun. Why wouldn't he say, I have no idea how he would have gotten the gun? We always secure that gun. So he didn't say that. And she says because he knew that the shooter had access to the gun. Then she talks about Sean Hopkins. Sean Hopkins said that was the school counselor who they had the meeting with a few hours before about the math sheet. And Sean Hopkins said that he wanted them to get him help that day, or at least within 48 hours. And Sean Hopkins also felt very strongly. I thought that maybe she would make a point of saying that Sean Hopkins said that no other parent, whenever he explained to a parent that their son is exhibiting suicidal ideologies, that in every single case they would take their son home. This is something I thought that maybe the prosecution could have stressed, that Sean Hopkins, who's been in the school meeting with all these parents, with all these different kids who have had similar issues, that in every single case, the parents would take the kid home that day and start already getting the kid help. And here, these parents just walked out and said that they have to go to work. And then remember that in the opening statement, that the prosecution said that James Crumbley was a DoorDash driver, and really as a DoorDash driver, you can set your own schedule. It's not like you have to be in an office from 9 to 5. So what is this that he has to run back to work? You can go home, you can take your son home, and you can figure out hours later. And the defense attorney made a good point in her opening statement when she said that let's not belittle the DoorDash driver. He is a responsible parent, and he wants to view this job as a responsible job that he has to do. And therefore, he's not just going to stop his job in the middle of the day. You may work in an office from 9 to 5, but this is his 9 to 5. And therefore, if it's in the middle of the day when he can be working, he wants to work as a DoorDash driver. So the prosecution addresses this, which is a good move. Something that you should address in your closing arguments. If there's certain arguments that were made in opening, you should certainly address those in closing arguments. And that's what the prosecutor did. She said that she agrees with the defense attorney that the DoorDash driver is a real job and, of course, something that he has to do. But still, since it gives you so much flexibility, what does it take already to go home and check on the gun? And he didn't do that. Now, something else is that they said that there's a lot of information that, and of course, in the last trial, they pointed the finger at the school for the social worker for not realizing that this is an immediate threat and just letting the shooter stay in school, that they're pointing the finger at the school. But this is something that the prosecution says, is that the James didn't tell the social worker that one of his best friends just dropped off the map, his only best friend, that the shooter's only best friend just completely dropped off the map because he ended up going to Wisconsin for treatment for his OCD, and that they were in a fight the night before, or that he bought him a gun, or that it wasn't secure. He didn't tell all this to the social worker. So maybe the social worker wasn't perfect, but still, all this information the social worker did not have, Sean Hopkins did not have. And then she says, you may not like what the school did. Maybe you feel the school should have done more, but still understand that James Crumbley had a lot more information than the social worker. I keep calling the social worker. It's maybe just referred to as a counselor in the school. That James had much more information than the counselor in school did. So then what she does is she says that the cable lock, as you remember and from the trial, the cable lock was never opened. It was still in its bag. And the drawing on the math sheet was the exact gun. This is something also that James knew. If he would have spent a little more time looking at that math paper and putting a few pieces together, he would have realized that that gun that the shooter is drawing in the math sheet was the exact same gun that he was just bought, the 9mm. James should have realized that. Then she talks about them escaping, right, running away, hiding from the police. And she says that they left an Ann Arbor hotel and drove all the way down to a business site in Detroit to hide out. Obviously, they were trying to hide from the police. That shows consciousness of guilt. And then she also says that he tried to pretend like he was sleeping when the SWAT came in and broke down the doors and was making a whole bunch of noise, and he was trying to make it pretend that he was sleeping at the time. And she was trying to show that that was obviously not true. Also, all of their cell phones were off. Why would all their cell phones be off if the only reason why they would have their cell phones off is so that they should not be tracked? So that was also another point why they're trying to hide from the police. Again, consciousness of guilt. And then again, she stresses the fact that we don't take any pleasure in showing you these images and these videos and telling you how these children died. We just have to tell you the truth. And then she goes through each child, how each child died. And she's saying, look, we just have to tell you because it's just telling you the truth. Also, remember that there was a time where the shooter was actually playing with the gun or some of the guns and showing videos of him playing with those guns and sending those videos to his friend. And that was when James and Jennifer were both home. How secure can the guns be if you're home and your son is playing with the guns? That also shows that the guns were not secure and that the shooter had access to the guns. And then she talked about the journal entries, and the journal entries are really, really strong. The journal entries say the following. One of the things that the shooter wrote in his journal entries, I have access to the gun and ammo. And even though James said the gun was hidden, Still, he's saying that he has access to the gun. Then he also says, I have zero help for my mental problems, and it's causing me to shoot up the effing school. That's something that he wrote also in his journal, that he has zero help for his mental problems. Then again, I want help. This is what he writes in his journal. I want help, but my parents won't listen to me. And again, he wrote, my parents won't help me. Then he writes again on the math sheet, help me. Thoughts won't stop. Blood everywhere. My life is useless. The world is dead. And then the prosecutor says, how many times does he have to ask for help before his parents actually give him the help? They see the math sheet that says, help me. And when you're the parent and you're seeing that, how do you not help him? Especially with all these journal entries, which would corroborate the fact that he was asking his parents for help. And also the text messages that he sent to his only one and only good friend that detail the times that he's talking to his father or his mother, and they're just telling him to suck it up. And he's complaining to his friend that I really need help. I want to go to a doctor and I'm emotionally dead, things like that. And it seems that the parents are just completely turning a blind eye and a deaf ear. And then she says they see all this and they just go back to work. James just goes back to work. All right. So that's how her closing argument essentially ended. And again, very, very strong. So I just want to start, before I jump into the defense's closing arguments, I would just want to, sometimes as an attorney, you're going to have your closing argument all ready to go. I mean, I shouldn't say sometimes, all the time. You're going to have your closing argument ready to go when the judge says, okay, closing arguments. You're not just going to think about it on the fly. But there are times where you'll have your closing argument already made. But then the prosecutor or the plaintiff, whoever goes first, is going to say something in their closing arguments. And you can really capitalize on something that they said. And you can spin something that they said and give it a little bit of a different feeling to the jury. And I think that that's very powerful if you're able to get up and not just have your script that you go by. Now, of course, the script is going to be very good. It's going to have your arguments and everything like that. But if you're able to pick up right away on something that the prosecutor just said, that can be very, very powerful. So as I was sitting watching this, the closing arguments, I was thinking, if I'd be the defense attorney, the first thing that I would do when I get up there is, because the prosecutor just said, and again, by me saying this, by the way, I don't want anyone to think that I'm taking sides. I'm not taking sides. I'm just showing you different tactics and strategies and how I would approach this if I was the defense attorney. So, okay, let me get back into it. So you see the prosecutor. The prosecutor just said a number of times in her opening statements that the reason that she showed these videos and the reason that she showed these pictures is because she's not here to convict people. She's here for the truth. And therefore, she has to show these pictures and videos to the jury. I think that since she stressed that so many times, I think it's a great point for the defense to get up and say something like this. All right, ready? Here we go. Prosecutor just told you that she's not in the business of convicting people. She doesn't want to convict people. She's just here for the truth. She just wants to show you the truth, and that's why she was forced. She was compelled. Her hands were behind her back. She just had to show you all of those graphic videos and pictures of these 4 innocent children that were dead and shot, and explain to you the manner of death and how they died and how many bullet holes they had through them. Now, I don't want to belittle anything, and I'm not. This is a tragic and terrible thing that happened, and no one is ever going to dispute that. And you know what else we don't dispute? No one is disputing in this courtroom that these 4 very innocent children died and were shot and were murdered in the most horrific, terrible, tragic way. No one is disputing that. If you want to just talk about the truth and you just want to show the jury, you just want to tell the jury the truth, well, we all agree that the shooter went in there and shot up the school and shot these 4 children. What is the point of showing you those pictures? What type of truth do you need to hear more than everybody agreeing that those 4 students were shot? This case is not about whether those 4 students were shot. This case is not about the shooter. We all agree the shooter has been convicted and sentenced. So you tell me, what is the purpose of showing you, the jury, the fact finders of this case? What is the point when you have to decide whether James Crumbley was grossly negligent in his duty to supervise his child or make sure that his son doesn't have access to the gun? What important fact are you going to learn that's going to help you make that determination in this case by seeing those graphic videos and those pictures of these 4 innocent children who were gunned down? Tell me, what is the truth that you need to hear about that? We all agree. And this prosecutor is getting up here and telling you that she just had to. She was forced to. She wasn't forced to. We all agree that it happened. This case is about James Crumbley. This case is about whether he was grossly negligent. That's it. What does it have to do with actually showing you how many bullet holes these poor children had? The only conceivable reason why the prosecutor would show you those pictures and show you those videos is to invoke sympathy. That's the only possible explanation. There is no other explanation that makes any sort of sense. And maybe she can get up here now in her rebuttal and explain to you why it's not enough for you to understand the truth of the matter, which is that these 4 students were gunned down. And if we all agree on that fact, then that's the truth. The truth just came out. What more truth do you need to hear or understand by seeing a picture of it? Maybe she can get up here and explain that. And this is a prosecutor who also told you that she's not in the business of convicting people. Really? Well, this is the first time in the United States history where parents are being charged with the murder that their minor child carried out. This is not a prosecutor who is looking for convictions. What about all the other hundreds of prosecutors that lived throughout the entire history of the United States who decided not to do this? This is not about the fame. This is not about the cameras. This is not about the pictures. Now, maybe I'm taking it a little bit further. Maybe they would invoke some objections. But this is the point. The point that you want to make is that we are here making history. This is the first time ever. And something that the defense attorney did say as she started her opening statements is that, and she kind of said it in a very mellowed down way. I think it wasn't said with like enough, I feel it just wasn't said strongly enough, that she said, there's been a lot of school shootings and there's been all these coalitions and meetings and people are trying to figure out how to stop these school shootings. And this is the first time in history that parents are actually being charged. Now, I think it could have been stressed a little bit stronger and let the jury understand that this is overreaching. It's just overreaching. This is not about the truth. This is not about a prosecutor who just wants to just show you the truth and advocate for victims. Hundreds of prosecutors have done that without charging the parents. So think about that. All right. So that would be just a point I think it's worthwhile making. And there you're kind of hurting that whole suggestion. And again, you stress, ladies and gentlemen, this is not about the shooting. And this is only the only reason why you were shown that was to invoke sympathy. And there's a specific jury instruction. And then show that jury instruction to the jury. Have it up on the screen that you're not to make a decision based on your sympathy in this case. So now that we can get that all out of the way and try to unsee everything that you've seen in those pictures, now let's actually talk about the evidence. The evidence that actually is relevant in this case. The truth that actually is relevant to James Crumbley, whether he acted grossly negligent or not. And I think that would have been a great way to start off. And that's just something that you got to think about on your feet. And it's tough. And maybe the defense didn't want to deviate from the script that she already had. But it's just something that a lot of times when you're sitting there at counsel table and you hear something, you can really use that and piggyback off of something that the prosecutor said, make that point, and then move on to the script. So yeah, you got to go a little bit off script. You got to a little bit think on your feet, but sometimes it's worthwhile. All right, let's move on to the defense closing. So the defense said that, again, like I said, she said that this is the first time that parents were charged for the murder of their the minor children carried out. And she agreed that this is a tragedy. Of course, you got to do that. And she said that this case is really based on assumptions and hindsight. And this was kind of a theme that she was bringing out during her cross-examination, which was good. Because you have to you want the jury to be hearing your theme as you're cross-examining the witnesses. And this is something that once you hear in closing arguments, you say, oh, that's why she was making all those points with those witnesses. And that was a good thing that she said, that this case is based on assumptions and hindsight. And she kept talking to the witnesses, if you remember. She would talk to the witnesses. This is something that you have the benefit of looking back at now, right? And the point of that is that, yeah, now after everything happens, hindsight is 20/20. But that's not what your determination should be based on. Your determination is based on what James knew at the time that the shooting happened. So that was a good point that she made. And then she agreed that Sean Hopkins, who was the counselor, said that it's easier to look at things in hindsight. And then she stressed that he had no knowledge that his son was a danger to anyone. And this is also a point that she kept bringing out during her cross-examination on the different witnesses, that each witness, she would say, do you know whether James Crumbley knew about this? Did you know whether he knew that his son was writing this in a journal? Did you know that his son was writing this in text messages to her son? You have no information about that, do you? And that was something that she brought out during cross-examination. So again, she revisited it in closing arguments, which was good, to show that, look, we proved to you that there's no evidence at all. Not that we proved to you, but there's been no evidence. The prosecution has the burden here. And that's something that she stressed also. The prosecution has the burden. She has no burden at all. And that's something also you got to stress when you're the defense attorney, that you have no burden here at all. And even though that she has no burden, but the prosecution has the burden, and they have not failed to show you that James knew any of this. James had no knowledge of these text messages between his son and his friend. He had no knowledge of what he actually wrote in the journal. There's been no evidence of that. So you can't infer that he did know about it. There's been no evidence that he did know about it. He had no idea what was going on. And then she talks about a beyond a reasonable doubt, which of course you've got to stress, and I always talk about, you've got to explain how high the burden of proof is beyond a reasonable doubt, which she did. Something that, again, that I think that she should have spent a little bit more time on is explaining gross negligence. And you're going to think that I'm a broken record at this point from all of these involuntary manslaughter murder trials that are going on, and why it really comes back to this same idea, and why the jury really, really has to understand this. When you're the defense attorney, yes, beyond a reasonable doubt, of course, you've got to stress that. But also, explain gross negligence. And explain more about the judge told you it's more than just carelessness, and it's more than just negligence. You as the jury may find that my client was negligent. Maybe he was very negligent. That still doesn't get you to gross negligence, willful disregard. Could he care less? Are you telling me that James Crumbley could care less about whether his son would shoot up a school? If you decide that, then that's gross negligence. If you just decide that he should have been a better parent, and that he was negligent in the way that he was parenting, perhaps, that is not enough. And I don't think, again, that was stressed enough in the defense attorney's closing argument. Then she continues that you don't need to use a cable lock to secure a gun. And she said that even one of the detectives agreed to that, you could use other means to secure a gun. You don't need to use a cable lock. Another point that she made, which was a very good point, smart point, is that one of the witnesses testified that there was a certain video of the shooter playing with the gun and loading the gun in a very unsafe way in his house. And the phone records showed that James was in the house at the time that he was playing with his gun, and it made loud noises. And she was saying how the witness was saying how this makes loud noises, and therefore James would have known of that he was playing with the gun. He should have known. And here, the defense attorney says, look at James throughout the whole trial. He was wearing headphones because he's hard of hearing. So it's not so hard to imagine that he was not able to hear his son playing with the guns. Now, this prompted an objection by the prosecution because there's been no evidence admitted during trial that James is hard of hearing. So how can you argue things to the jury? You're allowed to make arguments, but you have to argue it based around the evidence. So she jumped up and she made an objection. But the judge still allowed it in because the judge did instruct the jury at the outset of the trial that James is going to be wearing headphones because he's hard of hearing and they shouldn't hold it against him or anything like that. So once that's already in, it's going to be hard for the judge to say, no, you can't talk about it. She instructed the jury that he's hard of hearing. So it's kind of like something that's judicially noticed. So that's why she allowed the defense attorney to talk about it. But that's a great point. It's a great point that whole part to show how negligent James was because he let his son play with his gun even though he knew it because it was making all these loud noises, not necessarily. So that was a good argument that the defense made. She said that the sister came, right? One of the James's sister testified. That was the one witness that the defense called. And she said that she saw everybody in June of 2021 and she didn't have any concerns about anybody. She saw James, she saw the shooter, and everybody looked fine. So did the shooter look fine. She had no concerns. Also, she said that Sean Hopkins said that James sat next to his son in that meeting with the school counselor that morning. He sat next to him. He was caring. He was talking to his son. He told his son that you can talk to me. And this was a little bit different than the Jennifer Crumbley trial. You'll remember that part of the evidence that came out in the Jennifer Crumbley trial is that how standoffish she was when she got called into that meeting. She showed no love to her son, and she seemed very annoyed, and she didn't even look at him the entire time. Well, here, James was sitting next to his son and showing his son that he actually loves him and cares for him and that he's there to talk to him. And let's not forget that Sean Hopkins, the school counselor, told them that this is not something that needs to be done immediately. Now, he did say that he wanted it to be done today and at least within 48 hours, but it wasn't something that needed to be done immediately. And therefore, that was a point that the defense wanted to make, that here you have a mental health professional who sees kids with problems all the time, kids that are sad all the time, and he didn't feel that he needed anything to be done, anything emergent to be done. And she said, let's not forget that the son wanted to stay in school. Now, again, now we know why he wanted to stay in school, but his son expressed that he wanted to stay in school and asked for his paper back or wanted to finish up the work. She said that James told the police in the interview that he had no issues with his son. There's been no disciplinary issues with his son. So if you have a kid who's constantly getting into trouble, that would raise more red flags. But here, there's been no discipline issues with the shooter in school. So that's another reason why they shouldn't feel that there's anything that's seriously dangerous about their son. And then she talked about Christy Gibson Marshall. And this was something that was very, very important for the defense to stress in her closing argument. Christy Gibson Marshall, remember, was the assistant principal who actually spoke to the shooter. The shooter saw her and she spoke to him. And one of the things that she said, and this is something that the defense attorney said in her closing argument, I think she should have said it a little bit differently, but she did stress this, which was a good point, to say that Christy Gibson Marshall was surprised. You're right. Remember what the prosecutor said? That everybody was shocked? I think she could have stressed this a little bit more, the defense attorney. She could have stressed this. You're right. The prosecutor was right. Everybody was so shocked. Nobody thought that this shooter would be capable of doing such a thing. You know who else never thought that? His parents, James. So that was a point that she could have stressed a little bit more, but she did bring it out on the fact that Christy Gibson Marshall said that he was a good kid. Now, she actually said something different. She said in her testimony that he was a sweet kid. I think a sweet kid is a little bit better of a description for you if you're on James Crumbley's side. He's a sweet kid. A sweet kid doesn't sound like someone who's going to do anything. A good kid is a good kid, but even good kids can do bad things. But a sweet kid, I think it's a little bit of a better picture to say he's a sweet kid. And that's actually the words that she used. And she said that Christy Gibson Marshall said that she was so shocked that it could be him. And she said, remember, that the school didn't really feel that the pictures that he drew on that math work were so concerning. It was more the words that he wrote. But again, she just wanted to say that those pictures of the gun and of the depiction of a person with blood coming out of them, that wasn't so concerning to the school. It was more so the words. And remember, the reason why she's stressing that is because the prosecution said that this exact picture of the gun was the exact gun that James bought for him. So James should have put the two together that this is the same gun that I just bought him, and this is what he's depicting on his drawing as shooting up the whole school with. So he should have thought about that. But she's trying to make the point that this is something that even the social worker didn't think that there was any, I keep saying social worker, the school counselor didn't think was so concerning. Now again, the argument back is that there was much more information that James knew that the school did not know. The school did not know that he just bought him the exact same gun. Also, let's remember that this is a hunting community. Kids handle guns all the time. They go to the shooting ranges. It was very normal in the Oxford school system for kids to be doing that. And then, again, the question that the prosecutor said, why didn't James go home? Why didn't he go home after that meeting to make sure that the gun is there and secure? And then to this, the defense responds, why would he? He didn't know anything. Remember, he didn't know all of those text messages. He didn't know what he wrote in the journal. And therefore, how can he know what his son was planning? And therefore, if there's no reason to go home, why would he go home? Even if you're so close to home, if there's no reason to go home, why would you go home? And then she said that even when the shooting was going on, still, Sean Hopkins and Nick Ejak didn't even think that it was the shooter. They didn't put two and two together themselves. Now, something that I wanted to make a point of with the journal, and I think this could have been a point that was made that the defense attorney did not make, and that is, let's remember that the journal was found in the bathroom with the backpack of the shooter. So the shooter wanted that journal to be found. That's why he left it there. That's why he brought it with him. Is the journal something that he brings with him wherever he goes? It's hard to imagine. So why would he want that journal with him? He wanted to write one last thing before he committed this horrific shooting? You could also make the argument that the reason why he had that journal is because he wanted an excuse. And by pointing the finger at his parents, how he had all these mental issues, and that his parents were just completely ignoring him. And that's what the journal says, essentially, that they're just ignoring him, and he's asking for help, and he needs a doctor. And he's writing this in his journal. And because he's not getting any help with his mental issues, he's going to shoot up this school. It sounds, you can make the case, at least you can make the argument, that he wanted that to be found. The shooter wanted that to be found. And he's creating a narrative himself, and not necessarily does a point to the fact that he was actually asking his parents for help. Could be he's just creating a narrative that he wants to be found and blaming it on his parents when really that was not the case. So I think it could have been explored. Again, I'd have to see more of the journal, the entire journal, but I think that maybe that could have been a point that was made. And then the defense attorney finishes with the fact that I don't get a rebuttal. And this is something important. As a defense attorney, different defense attorneys want to do different things with this. The fact that they don't get to rebut what the prosecution says. And the way that this defense attorney said, and the way that she wanted to tell the jury about this, is that, look, I don't get to make a rebuttal. And she said, this is my least favorite part of the case, that I don't get to make a rebuttal, because I can be sitting there in my chair and I'm just going to want to respond to some of the things that the prosecutor says, and I have to stay quiet, because that's the way the system is. The plaintiff the prosecutor has the burden of proof, so she gets to go last. And then she tells the jury, but you already know me, you know my personality, you've been watching me, and you kind of know how I think, you kind of know what type of arguments I would make. So just think to yourself, what would I say after you hear the arguments that the prosecution makes? What would I say in that situation? And if you do that, then you'll be able to come and realize what I would answer, and therefore you'd be able to get to reasonable doubt. And here the prosecutor gets up for rebuttal, and here she uses exactly, this is like on the fly, this is something I just spoke about in the beginning of the video. When you're able to use something that the other attorney just said, it's very powerful. So she gets up and she says, you know what my least favorite part of the trial is? My least favorite part of the trial is that even if there's a conviction, it still doesn't take away any of the suffering, doesn't take away any of the pain. All these families that they have to go through, all the pain and suffering that they have to go through. And then at this point is when she embraces her burden of beyond a reasonable doubt. And you know that I always speak about that you have to embrace, when you're the prosecutor, you have to embrace the burden of proof. Because if you don't, then the defense attorney is going to get up there and start talking about how incredibly high this burden is. And that's probably why the prosecutor didn't even mention it. And that's also something that she could have mentioned, by the way, the defense attorney could have mentioned in her closing arguments. She could have said, you notice how the prosecutor didn't talk so much about the burden of proof? You know why that is? Because it's such an incredibly high burden. She just wants you to think, yeah, he probably did it. It's more likely than not that he did it, or even if it's clear and convincing that he did it. But that's not the burden. The burden is, even if you're pretty sure that he did it, or you're pretty sure that he's guilty, but if you have any reasonable doubt, then you have to come back with not guilty. Now, something the defense attorney did not do. I think it could have been done. But here in the rebuttal, this is where the prosecutor does embrace her burden. And I think she should have done it in her closing argument because she gets to go first. And if she doesn't, then the defense attorney can really capitalize on the fact that she didn't mention it. And then, of course, in rebuttal, she has to mention it and she looks a little silly. But here, she did embrace the burden, which is important. In her rebuttal, she says, yes, we do embrace beyond a reasonable doubt, and we're happy to, and we can prove to you beyond a reasonable doubt, et cetera, et cetera. And she said a few more things, something that we already heard in her closing arguments. And she said a lot, you have to use your common sense. This is also a theme that you want to always stress to the jury. Just use your common sense. What do you think really happened here? Do you really think? And she also had to make the point that she did in her closing arguments as well as the rebuttal, that something that she probably foresaw from the last trial, because this is something that the theme of the last attorney was in Jennifer Crumbley's trial, was that we're going to start putting all parents away. If we convict Jennifer Crumbley, then it can very easily be you or me or a loved one or a friend can be sitting in the same exact chair. And this is where the prosecutor wanted to make the point that that's not true. That's not what happened here. We're not perfect parents. Nobody's perfect parents. But there's still certain things that we would all do as required by law. And that's all. If you do those things, those few very basic and easy things, so then you would not be sitting in that chair. The only reason why James is sitting in that chair is because he didn't. He ignored it over and over and over and over again. And this was really the theme of her rebuttal. And again, it was pretty strong. So that is the closing arguments on this case. And we'll see again what the jury does on this. We're going to be deliberating more tomorrow. And that will be it for today. Please, if you haven't yet, subscribe, like the video, and we will see you next time.